Welcome everyone to Greenway Chambers, another one of our CPDs that we hold as part of our super series in March, this one on work health and safety. So work health and safety proceedings, I'm sure everyone listening is familiar. We're talking about criminal proceedings in which the prosecutor alleges that a person in control of a business or undertaking has failed to ensure compliance with a duty held to ensure that they've done everything reasonably practical to ensure the safety of workers. And we're looking at a focus on eliminating risks and steps taken to eliminate risks. Now, all of that is conveyed in a charge. And the charge, as you know, is somewhat more complicated than a traditional criminal charge of drove in a manner dangerous. What is critical in a charge is the pleading and how two things in particular are, to repeat the word, particularised. The first is the nature of the risk or risks, and secondly, what were the things that that person should have done and was reasonably practical to do, which if done would have either eliminated or at least minimised those risks arising. So that's a long way of saying that this seminar is effectively going to focus on the summons. We're going to start with Malcolm Scott, who's going to talk about the particulars, the drafting of the particulars. I'm then going to say something about amendment. And by amendment, I'm not talking about the amendments that are commonly negotiated as part of a plea deal. I'm talking about the prosecutor's capacity to amend the pleadings well after they have commenced. That then can give rise, amongst other things, to a question of costs. And Justice Penn will be speaking last on costs generally, which frankly, clients are always keen to know about. And one of the things he'll touch on is costs that might arise from a late amendment to the pleadings. So, first up, Malcolm Scott. For those who don't know Malcolm, he has, I think, run more work health and safety matters than anyone at the bar, which actually reminds me, before I go any further, whilst he's not speaking, I do want to specifically mention our newest floor member, Colin McGee, who would not be far behind Malcolm in the sense that he has a fantastically massive work health and safety practice, and we're very pleased that Colin, whilst he's not speaking, is able to join us today, and I'm sure we'll be able to the extent he's got the capacity to stick around to the end when we get to questions, we'll be able to contribute to that discussion as well. But anyway, without further ado, Malcolm, over to you on the first topic, particulars.
Thank you, Ingmar. I do not wish it to be thought that this is my favourite topic. It's a bit dull, but it is the kernel of all that we do in work health and safety prosecutions and defences. So I thought about time we revisited the basics. Now, the first thing you need to look at is the statutory basis. And the statutory basis for a pleading is Section 11 of the Criminal Procedure Act, which is as short as that. Description of any offence in the words of an act, statutory rule, is sufficient at law. Now, if you wish to assume that the charge is a charge of breach of Section 32 of the Work Health and Safety Act, then, and I must say it's a breach of Section 32, not a breach of Section 19 and Section 32, which we'll often see people refer to. Section 19 is a duty. There is no penalty for breaching a duty by itself. Section 32 is the charge, and that's has the penalties that are attached to it. Now, that has, as you can see, a number of elements that have to be proved beyond reasonable doubt by the prosecutor. They're set out there in A, B and C. That generally is then translated into a pleading. This is a particular pleading, which has been anonymised, which sets out the details of the offence. The essential elements which you've just seen in section 32 are named there. So you've got the name of the company, the PCBU, undertaking had a duty, which in this case is 19.1. Sure, as far as reasonably practicable, the health and safety of workers whilst they're at work, and they did fail to comply with that duty, and that failure exposed somebody, a worker, to a risk, or a person to a risk. Now that pleading by itself is, under section 11, sufficient in law. The common law, however, kicks in. There's a very old case called Johnson and Miller in 1937, which said, the High Court said, looking at something similar, section 11, that it only relates only to the nature of the offence, does not dispense with the necessity of specifying time, place, manner of the defendant's acts or omissions. Even that little bit. That's why in the charge you'll then see the date that it is said it occurred and where. Now, the charge as generally provided by usually SafeWork sets out a number of particular headings as to the different parts of the pleading. In Kirk, the majority found that section 11, this is a paragraph 26 for those of you who are really interested in Kirk, paragraph 26 in Kirk, the majority found that section 11 did not dispense with the necessity for the defendant not only to be told the legal nature of the offence, but also the particular manner and thing alleged as the foundation of the charge. And further, that the statement of the offence must identify the essential factual ingredients of the charge. Now, they're relying also, or referring back to, another old New South Wales case called John L. It should be noted, just parenthetically, that both Kirk, John L., that range of cases, were all dealing with charges about which there was a defence. Most criminal charges have a defence. These don't. This is section 12, capital A, said this is, these acts are acts of strict liability. You no longer have a defence. And therefore, there is some overstatement, if you like, as to what needs to be provided by a prosecutor to our defendant. Because under the John L. and Kirk, you need to not only give such particulars that enable our defendant to understand the case being brought against them, but also the basis for which a defence might be brought. So that doesn't arise. Now, as I showed you before, section 32 relates to a breach of duty by a defendant. Looking at section 19.1 and 19.2, which I've set out there, the essence of a section 19.1 or a 19.2 breach is in fact that there is a risk. Risk is probably the key pleading. And a lot of care has to be taken with it, and a lot of attention should be taken to it by a defendant. It can't be too specific, because if it's too specific, then it tends to fail being a statement of risk and runs into a pleading of a particular event. In other words, on this day at this time, this person put their hand inside this machine and lost 2 fingers. Rather than it being a pleading of a risk, that the happening of that event being nothing more than the manifestation of that risk. In other words, there was a failure to properly guard the machine. So the risk was a person who was either operating the machine or in the vicinity or maintaining the machine ran a risk of being suffering serious injury or death by coming into contact with moving parts of the machine. That's a statement of risk which is relevant to a charge rather than the particular person. If the risk is too broad, however, it'll fail because of an inability to particularise how it is said it arose and what should have been done about it. If you put a really broad statement about workers were exposed to risk of their health and safety because there was, over a period of 15 years, an increase in carbon dioxide in the room they were working in. It's far too broad. No way in the world you can particularise it down to a proper statement. Now, having then pleaded the risk, you are then required to identify what reasonably practicable steps the PCBU could or should have taken to either eliminate the risk, or if you can't eliminate the risk, then you need to minimise. Now, going back to section 19, you can see that picks up paragraph 1. It also is in paragraph 2. Must ensure so far as reasonably practicable. The prosecutor will therefore, and the defendant will need to concentrate on what it is specifically said they should have done to eliminate the risk or minimise it. The effect of Kirk and others is that it is this isn't a dry exercise. This is a living exercise. If you're saying this risk was created by this person and that led to that person or these persons all being at risk of serious injury or death, you then need to say why you're saying that. What did they not do, or what did they do that they shouldn't have done? And that is the particularisation. The problem, however, and the temptation is, and you'll see this from time to time in a number of cases, of particularising every single possible omission. Now, when that happens, attention tends to move away or diffuse from that which is really reflective of the seriousness of the offence. So it's the art of the prosecutor to find down what the real issues are and what the big things or most important things that will fail to be done to reflect the risk. Now, that leads me to further and better particulars, which we go in waves in this particular jurisdiction of activity. Every now and then we go through a particular concentration where a lot of further and better particulars are asked. Sometimes that can simply be because the people who are engaged by the PCBU are used to doing common law work, where, as we know, lengthy further and better particulars is quite usual. But the role of further and better particulars in this type of work is a much narrower and more specific, and that is to clarify or enable a better understanding of what the allegation is. It should be remembered that the prosecutor does not have to particularise chapter and verse. That isn't a feature of the criminal matter. Now, part of that is because there is no defence under this Act. So really what you would expect a defendant to turn their minds to the nature of the risk pleaded, further particulars about that, and trying to ascertain whether there's an argument the risk did not exist at a time and place particularised. Secondly, what steps were reasonably practicable to eliminate or minimise that risk. And thirdly, whether if the steps identified had been taken, they would have obviated the risk, and if not taken, would have exposed the individual to a risk to their health and safety. Because they're basically the things that have to be proved beyond reasonable doubt. And therefore, they're the things that have to be set out clearly in the particulars. So that should be the concentration. There are some matters which are few in nature where the concentration may well be on an argument that the duty did not exist at all. There was no duty as pleaded, but they're fairly rare and reasonably specialised. Now, there isn't a lot of purpose gained in my experience in defendants writing lengthy page after page, further and better particulars to a prosecutor in this area of work. That will tend really just to run up the costs for both sides and won't get you any further, rather than get an understanding of what the particulars are. So really, just as a prosecutor in the area of particulars should exercise a skill in drafting very precise particulars, the defendant should exercise its skill in honing down the matters of substance and importance, which they genuinely need clarification. And the last thing I want to say, something that comes up from time to time, and in fact has quite regularly come up in the last 12 months, is the tone of the request for further and better particulars. The idea that a bullying or hectoring tone is going to get you a better result from a prosecutor is probably fallacious. If you're using a bullying and hectoring tone, it's very unlikely to improve the necessary cooperation between a prosecutor and a defendant. And I think that's quick enough, isn't it?
That's very good. Thank you.
He told me I had to be very fast.
I can't help feeling that Malcolm was in particular revisiting some particular recent correspondence that he had to deal with at the end there. Thank you, Malcolm. We're going to have some questions at the end, provided Justin and I are as good as Malcolm at sticking to our timeline. But if you have a question as we go, and you're in the room, just start speaking. I'll have to repeat it for the microphone purpose for those not. If you're online, I've got a screen here with the words live chat. Feel free to send me a message right now, but particularly if you have a question, I'll do my best. There are 30 people. There are more people online than there are in the room, although we've actually got a pretty good turnout in the room too, which is great. Now, let me click on amending a WHS charge. So those of you who practice in the area, you may be aware of this, but the way these things work is the charge is laid usually about almost exactly 2 years after the incident. Not exactly, but within a week, always a week before. And then there's a large brief of evidence that's served. Takes a while for a defendant to get on top of it. And a decision is made, possibly after a series of adjournments, to defend the matter in those matters where that decision is made. It can take a while before that occurs. It may well be that a defendant takes a view to have discussions with the prosecutor with a view to a plea of guilty, and then the charge is often amended as part of that. I'm not talking about that type of amendment. I'm talking about the type of amendment which occurs, and certainly in my experience, because I tend to get briefed at the point where your client decides to defend the matter. If I'm acting for the prosecution, I'm also acting for the defence and might be giving you advice in the first place. But assuming I'm on the prosecution side, I come into it at that point and I then look at the pleadings. And from time to time, I've taken a view that it's appropriate to amend them. And sometimes that view is formed quite close to the hearing. Now, that hearing might be some 18 months or more after the matter has commenced and significant costs have been expended. And in 2 recent cases, I made an application to amend successfully, and that led to the defendant asking for time to have discussions, and that then converted into a plea of guilty. And I really thought it would be useful for solicitors who are acting for defendants to understand what is involved, what the fact that amendments can be sought and successfully obtained at late stages, because it's important perhaps to understand that if you are advising your clients as to the potential to defend matters, that you have to think about the fact that you're advising them on a current pleading, but that might not actually be the pleading. All right, let's just have a look at the nature of the power. The power is found in Section 20 of the Criminal Procedure Act, and as you can see, it's set out there. There is no stated criteria. It's simply, you can do it with the leave of the court or by agreement. Section 21 does actually have a separate power to amend, which I'll come to in a moment, but that's only where there's a defect in the charge. So Section 20 has no guidance. When will it be amended? Well, the test, as you'll see there on the slide, has been stated in different ways, but fundamentally, amendments will be granted unless it can be established by the defendant that it would prejudice the right of the accused to a fair trial, or render the trial unfair, or create an injustice, or to use the words of Justice Russell, who I think has handed down the most comprehensive decision on this in a work health and safety context in Solvco, the accused would be unfairly prejudiced. And you've got to understand that is not, in a civil law context, some sort of unfairness disadvantage that you would have if someone at a late stage in a civil matter is making an application to plead some separate cause of action or so forth, where for reasons that the High Court discussed in Aon, the court might just say, look, I'm sorry, but no, you've had your chance to plead this case. I'm not, on the first day of the hearing, going to let you, alter the nature of your case. You just have to live or die with the pleading. That is not the basis upon which a criminal court will consider amendments. It's not just if one party is going to be disadvantaged. There's no concept of it being, quote, too late, close quote, in the sense of lateness itself being a decisive factor, and nor really costs. Now, I mentioned Section 21. This is a criminal case in which there was a defect in the charge. Now, Section 21 specifically says that you can amend a defect if it can be amended without injustice. And the court has said if that's the test with a defective charge, then no higher onus is going to arise for a charge that was actually an entirely valid charge. In this particular case, the charge was robbery with a knife. And at day 13, the prosecutor stood up and sought to amend the charge to robbery with a firearm. And that was because for 13 days the evidence had been that in fact one of the 2 accomplices had been standing at the doorway with holding a firearm and threatening the person. There was some evidence about a knife, but it was a bit sketchy. Now, the defendant objected to the amendment on the basis that they had carefully cross-examined. All the lead witnesses had gone through the witness box by that stage, carefully cross-examined and done their best to try and create an impression that there was no knife. And the decision of the Court of Criminal Appeal, they were convicted, appealed. The Court of Criminal Appeal effectively said, look, this isn't a sporting contest. You don't get to win on some technicality. No injustice arises simply because the amendment to the charge deprives the accused of taking a technical point based on an inconsistency between the statement of the charge and the evidence. And so you get this idea that if the evidence as it comes out, or, and this is common in work health and safety matters, as the evidence becomes clearer close to the hearing, when in a defended hearing context the prosecutor goes back and speaks to witnesses who prior to that time might have done nothing more than filled in a 155 notice, often with a crayon, yes, no, and you have no real idea of what their evidence is, then at that point you may well amend the charge. And you'll see Justice Howie's statement, it'll only be a case where the accused will be irreparably prejudiced in meeting the charges amended that leave should be refused. In Justice Howie again, in Lycoris, made the statement that it will be a very rare case where it will be refused, and talked about a case in which a judge, during the defence case at the very end, decided that given the way the defence had run the case, it would be appropriate to put before the jury an alternative charge, which the jury then convicted on. Wasn't even an application by the prosecution. That also was held to be valid. So you get in a criminal law context, it's a question of whether there's fairness to the accused, and there's nothing said to be unfair to the accused if they have the opportunity, sometimes where necessary by way of adjournment, to meet the case. And there's a public interest in ensuring that if there is a proper charge that someone can be convicted of, that can be allowed to be heard. That's certainly the approach that courts take. How late? This is something that sometimes comes as a surprise. First day of the proceedings, in the two cases I mentioned, in both cases I opened the case as the prosecution, having flagged in advance to the defendant by correspondence that we're making an application to amend. But I said to the judge, look, before we hear that application, let me just explain what this case is about. Opened the case and then made the application to amend at the conclusion of the opening, at which point the court has a very good idea of the nature of the case that has been served by way of a prosecution brief 18 months earlier. So one of those two cases was the decision, as I said, in Solvco. And in paragraph 50, you will get Justice Russell's summary of the principles. I won't read them to you, but you'll see in particular on the first of these two slides, because they go over two slides, the third, the defendant has no right to have a charge prosecuted on a particular factual basis. So in that case, it was originally pleaded that it was a waste recycling business, and they had various pieces of equipment to recycle sort of industrial waste. One of the pieces of equipment was called a shredder, and the shredder, you literally poured in aerosol cans, and this machine would grind them all up. But aerosol cans, by their nature, hold a flammable propellant that is heavier than air. And the prosecution case on this was that on this particular day, a large number of aerosols cans were shredded. There was a small amount of wind or breeze, but there was a fan that was actually there that blew the vapor, and there happened to be a man 20 metres away who was doing some water cleaning using a piece of equipment that wasn't intrinsically safe. An expression that I learnt in that case means the electrical circuitry is not vacuum sealed, so as you turn the machine off or on, you can create the smallest of sparks. As a matter of fact, and there was security camera footage from the neighbouring business, at about the time that his evidence is he turned this machine off, you see a small explosion and then a sheet of flame that goes from him back towards the shredder. So the prosecution case was there was a risk. The risk was explosion from failing to have intrinsically safe material, and Mr. Hender was the person doing the cleaning, was put at that risk. But as we got closer to the trial, I sought to amend to say that there was a second worker who was at risk, who was operating the shredder, because the shredder also had equipment that was not intrinsically safe, and any of that could have also set it off. Now, they had a defended hearing. Their defended hearing worked on a theory which not that I knew this because they hadn't disclosed this, which didn't work if Mr. Forsyth was added. It could only work on the basis that Mr. Hender was the only one that was at risk, that they sought to prove that whatever gas was released had not reached Mr. Hender. The reason Mr. Hender had gone up in flames was in fact due to what he was doing, was their case theory. Anyway, by successfully amending the charge to add a second worker, they then entered into negotiations, and ultimately the company pleaded guilty, and the guilty plea is another published decision. But you can see that it can come up late, and you can see how that can affect decisions that are made. In that particular case, the judge held that the added particular was within the case that had in fact been pleaded, and the fact the defendant had assumed that we'd be seeking to prove it only on the intrinsically unsafe equipment of Mr. Hender and not also on the other equipment was simply not. There was no particular that had been provided to that effect. Although he went on to say that even if he'd found the prosecution case was the narrower case perceived by the defendants, he would still have granted leave to amend because a defendant has no right to have a prosecution brought upon a particular factual basis. Given the public interest aspect of a work health and safety prosecution, and given that the amendments are sought in an early stage of the trial, the amendments would have been granted even if they did widen the prosecution case beyond the original pleading and particulars. Any prejudice to the defendants could be met by giving the defendants time to consider their position and apply for an adjournment. Sorry, I didn't click on to the second set of principles, but E is, again, the same one I mentioned earlier. It's a very rare case where it won't be granted. So you can see the potential issues that can arise for a defendant.
It's outrageous.
You can see the potential issues that can arise for a defendant in having to contemplate things. They can possibly be dealt with by way of an adjournment. What, though, can happen? I mean, the one thing I should be clear about this, the prosecution cannot lodge an entirely new charge, but you'll understand the way that charges are drafted, that the overall charge is a breach of duty, and then there is a risk, and then there are particulars of risk. Usually they come down in degradations of generality down to specifics. Amending a charge, and the second one I did was with Colin McGee in respect to Walgett Shire Council, amending a charge to say, when we said you didn't have a safe system, you in particular didn't have a safe system in this particular way, that is properly said to be a sub-particular, albeit the defendant's reaction is, hang on, we didn't think you were going to try and prove your case in that way. It's like, well, happy days we are. It can lead to an adjournment. But my point was, and I'll come to costs as the final point, it doesn't often lead to an adjournment. Obviously, it can depend on the nature of the amendment. If you were to add a whole new measure, for example, if you were to say, oh, and you should have had a particular piece of machinery, which we did not mention at any earlier point in the charge, at that point, then the defendant could quite rightly say, well, hang on, this aspect of the charge is new. We would need to get expert evidence. We need to consider this, and we can then seek an adjournment. And that the prosecutor has to weigh up those risks in deciding whether to take it. But costs, Justin's going to deal with costs in a minute generally, but costs, as you'll gather from him, are not at large, not like a civil proceeding where the court just has a general power to award such costs as deemed fair and appropriate in the circumstances. There is a power in respect of where it does lead to an adjournment, but it does come with that rider, which does tend to suggest that the costs that can be awarded are only costs that emerge from the adjournment. And what defendants can find in these situations is that they've spent a whole lot of costs assuming they can defend a matter in a certain way, and they may have a concern about, the fact they've got a whole. I mean, in Solvco, they then served us with a whole lot of expert evidence, which assumed that we were seeking to prove one case, when in fact that wasn't the case that we ultimately, and in fact, frankly, ever were going to seek to prove. But those type of costs may not be capable of being obtained or recovered. Implications. 4 implications. 3 of them are on the screen. The 4th, somewhat controversial because it's contradicting something that Malcolm said, possibly. The first is the point that I've been making about the prosecutor, to the extent to which you have any interest in the prosecutor's views about life, should be thinking about it. The second one is the point I've already made, that is, you acting for the defendant should be alive to the fact that the pleading may in fact change when you are giving advice. The third makes defendants even less likely to disclose a defence in advance. In that Walgett Shire matter, unusually the defendants filed and served expert evidence in advance of the hearing and disclosed an entire defence, which led to the first of the 2 successful amendments the prosecution had to say, oh, well, if your expert is right, nevertheless, there was still an unsafe system for this reason, which wasn't in the original pleading. And the last that's not there is that whilst Malcolm quite rightly said that not a lot of joy is to be had in lengthy requests for particulars, it does make it a little harder if you're acting for a defendant, for a prosecutor to amend. By no means removes the risk, but makes it harder if you do lock the prosecutor into certain particulars. At the very least, it gives you a proper basis later, which Solvco did not have because they had not sought particulars, to say this is a new case. As I said, Russell said, even if it was a new case, I would have still done it. But it makes it easier then to make your adjournment application and seek costs than it would if, in fact, the particulars are, as the prosecutor often says they are, no more than assisting the defendant to properly understand the case that they are to meet by providing some further and better particulars in the form of a pleading, for which you may not get an adjournment. However, you may, in fact, view the approach of the prosecutor. I hope I haven't spoken too fast, but as I said, there will be some questions, time for questions. But can I introduce our final speaker, who, as I said, will be speaking on the subject of costs. As anyone who's a litigation practitioner knows, people, when they come to the bar in their first year, are looking for experience. We're privileged to have one of the brightest young employment industrial practitioners that I've seen in many a year as one of our readers. That's Justin. He came from Harmer's Workplace Lawyers, and also he was a solicitor at the Marrickville Legal Centre and a tip staff to Justice Wright of the when he was then president of the New South Wales Civil and Administrative Tribunal. He's done a fair bit of work for me in employment industrial matters, but he also has an interest in this area, and I was very pleased that he was willing to cover this topic of costs because, after all, it's one of those things that you just want to know, and clients often say, but what about costs? And so to have these comments at the front of your mind, I'm sure you'll find very helpful. Over to you, Justin.
Oh, I'll click on. Thanks, Hima, and thanks everyone for attending this afternoon, either in person or online, but specifically in person. It's always great to have people in chambers. As Ingmar said, I'll be talking about costs, which is sort of the end of the procedural lifespan that we've talked about today. So you've reviewed particulars, those particulars have been amended, there's been an entire trial, and now we're talking about costs. That's the position we're in today, that's what I'll be talking about. But I'm not going to talk about the usual orders as to costs. That's the order that you'd see in every other judgment, that is the successful party pay costs as agreed or assessed to the unsuccessful party. I'm going to be talking about 3 unusual orders, and from those orders, hopefully, we can all obtain a better or a new understanding on, I suppose, the cost regime in WHS proceedings. further to something that Ingmar had said earlier, all three cases that I had located for the purposes of this presentation involve either or both of Colin or Malcolm, which again speaks to the ubiquity in the area. That was not deliberate, but those cases are, and I'll get to them, those cases are Safe Work New South Wales and Auto Care Services, in which an unsuccessful defendant was ordered to pay 75% of the costs of the prosecutor. The second case is Orr and Perilia Broken Hill. That's a case where an unsuccessful prosecutor was ordered to pay just 10% of the costs of the successful defendant. And perhaps most interestingly, in picking up something that Ingmar had just spoken about, the case of Safe Work New South Wales and Paletti, and that's a case where a successful prosecutor was ordered to pay the costs of an unsuccessful defendant in relation to costs thrown away in consequence of the late service of an expert report. And the Section 257F power to award costs in an adjournment was perhaps interestingly relied upon there, given what has just come from Ingmar about the narrow fetters of that power. And just to make sure that credit's due where it is, Paletti was a case that actually featured Ingmar, but in the Court of Criminal Appeal on a substantive law issue. So everyone gets a mention. Yeah, everyone gets a piece of cake. I don't need to go into that detail. So let's just start with a place where we always should be. That is the statute, the legislation, the source of the words that we look at that guide all that we do. The four key provisions in relation to costs in WHS proceedings come not from the WHS Act, as we all likely know, but from the Criminal Procedure Act. These provisions are 257B, 257C, 257D, and 257F. All of them are on the screen. All of them live on Austlii or New South Wales legislation and can be read there. 257F has a sub-paragraph, or a sub-particular, if you will, that raises the question, costs thrown away as a result of a prosecutor's amendment of an indictment. That's there because 257F, as mentioned, confers this discretionary power for adjournment-based costs thrown away. There is no separate power for example, amendments of indictments, no separate power for any other form of costs incurred or to be recovered. But as we'll see in Paletti, 257F maybe has a bit more work to do in the right case. Before we get to those three unusual orders, three sort of interesting cases, flowing from the statute, we should go to the general principles before we go to the heterodox principles. Those are that costs are compensatory, not a punishment for failure. William Timber Proprietary Limited. And again, in this theme of Greenway boosterism, I believe Colin and Malcolm were both involved in that matter. For the appellant prosecutor, there were two matters heard concurrently. That's a relatively recent case. It was handed down in 2021. And of interest is this clarification that a person's capacity to pay a fine is obviously an issue as to the size of the fine, but not to the discretion to pay costs. Costs are purely compensatory. They have nothing to say about any sort of punitive aspect. And if one is to avoid what might be thought of as a double burden of paying a fine and paying costs, where a defendant, a client, a party, is likely to be oppressed by both orders, the true position, the proper position, is not to seek leniency or grace from costs, but to receive a lower fine. That's essentially the position in William Timbers, and incidentally was exactly the approach taken by Judge Scotting in Safe Work New South Wales and Matthew Albans, a 2016 District Court case. So this position is orthodox and perhaps was orthodox beforehand as well. It's also the case that costs per Nash usually follow the event in the way described by those statutory powers. That costs may be discounted where there are multiple discrete issues and a party succeeds on some only, and that we'll see arise in some of these unusual orders cases, which are there. But also, as again we would likely all be familiar with, cost orders can be and often are very tailored to the disentitling conduct of parties in a case. In Nash and Silver City drilling, an issue arose as to costs incurred in respect of particulars that were introduced by amendment of the charge, but which were later withdrawn and ultimately not relied upon. In that case, the court ordered that the accused pay the prosecutor's costs, quote unquote, not including any costs incurred in preparation for a trial in which the particulars withdrawn in the further amended summons were to be relied upon. So a cost order can be made very specific where there is perhaps some disentitling conduct. And that's just something, again, to keep in mind when seeking a cost order that isn't the usual as agreed or assessed, because there are carve-outs, there are variations that can be considered. As to the three cases to be discussed, and noting the time, the first is auto care. In that case, a defendant had pleaded guilty to a variety of the charges of the particulars against it, but not guilty to others. There was a disputed facts hearing, and the prosecutor pressed the balance of the amended summons. The prosecutor subsequently failed to establish those particulars, and it was against this backdrop where a defendant has pleaded guilty to quite a few of the particulars, pleaded not guilty and succeeded in the balance, that the court was called on to determine the issue of costs. The prosecutor was successful, so the issue was what costs should be paid to it, if any. In auto care, the court ordered that the defendant pay 75% of the costs, and there were some quite useful observations made. Without descending into the specifics of that case and the specifics of those observations, the following general observations, I think, are pertinent because they are exactly that. They're very general and they apply to potentially all cases. The court took into account and made these observations, that the prosecutor, there were 8 in total, that the ones I'll mention are the first, that the prosecutor had a public duty to bring these proceedings and was justified in doing so, inter alia, by the plea of guilty and by auto care. The second observation, that there would have been considerable work done by the prosecutor and considerable costs incurred by formulating the charge, drafting the pleadings, collating the evidence to be tendered, and preparation generally. And as I mentioned, there were 6 more observations, some of which were more particular to the matter at hand. But those 2 really could be said about any case, and really could be said about any case in which a prosecutor is successful, even or exclusively on a guilty pleaded basis, but is still entitled to their cost, to its costs, despite a lack of success on other bases. So that's, I suppose, one situation where, again, costs were reduced, arguably on a basis where the defendant had done very much to reduce its costs and had been successful on quite a few, on the only contested grounds. The second case, Perilia, involves an unsuccessful prosecutor paying just 10% of defendant's costs. This case is very fact-specific in relation to the breakdown of those costs. Again, in the interest of time, there were two defendants. It was a joint trial. The second defendant was a holding company. The second defendant was successful in its defence of the defended trial, and it sought its costs. It sought actually 55% of its costs. The rough numerical breakdown of that was 10% of the trial was spent on an issue on which it was successful and which rendered the not guilty verdict. 90% was spent on other issues. Perilia said, that is, it should get the 10% of its costs on which it was successful, and the balance of 90%. Let's just cut that down the middle, and we can add that to 55%, and we'll take 55% of the costs. The court took a closer look at the findings in the case, the findings that it had made in the case, and it had rejected that submission from the defendant, finding that it presumed it was at least 50% successful, I suppose, on the 90%. The court also sort of took observation on the factual findings that were made in that case, and those factual findings pointed to favour the prosecutor, but for that 10% in which it was successful and on which it ultimately was found not guilty. So that's Perilia, and that's a case where the defendant's costs were reduced.
Just as a short anecdote on that one, the defendants suggested that their 10% costs, well, what they asked for their 10% costs was greater than what the prosecutor asked for its 90%.
Again, some creative algebra from the parties there. Yeah. And the last case is Paletti. And this most strongly connects with Ingmar's presentation, and in fact was something that Ingmar had raised with me in talking about it. It was a sort of, if you don't talk about it, I will. So I took the mantle of talking about it. And that involves an order that a successful prosecutor pay costs to an unsuccessful defendant, which is relatively rare, but 257F is agnostic to ultimate success. So in this case, the defendant was found guilty in the defended hearing, but the unsuccessful defendant sought its costs thrown away, consequent on a prosecutor engaging an expert, but deciding later not to lead any expert evidence at trial. The court there found that the prosecutor had been in breach of several court directions to file the expert report, that the prosecutor had agreed to serve the expert report 6 weeks before it had retained the expert. The expert report was described as, quote-unquote, highly questionable, and the main conclusions of the report did not amount to expert evidence, so the court observed, because they rose no higher than the application of common sense to the facts alleged by the prosecutor. A sort of R. and Honeysett sort of opinion evidence, thrashing. It was also observed that the prosecutor should have known on receipt of the report, having found what I just described, that its prospective usefulness was very limited, and that a decision should have been made to not rely on the report much earlier than at the conclusion of the evidence at the hearing. Notably, and this is that interesting quirk of 257F, that crack in the door that lets in more light than maybe you'd think, the court ordered that costs thrown away by the late services report should be paid to the defendant, but also the vacation of the hearing on the 12th of March 2019 and the preparation of the defendant's expert report. So there's, to use a civil term from a slightly different context, a slight remoteness to the preparation of the expert report as compared to an adjournment or the cost thrown away from the adjournment. But it's something of interest, and again, an unusual order where the usual order is just agreed or assessed. That's all really I wanted to say about costs, and perhaps all you really wanted to listen to about costs. But if people had any questions for me or for Ingmar or for Malcolm about any of the things that we've raised, please raise them.
Yeah, take a seat. We'll do our best. Now, we don't have a roving mic, so if there are questions for Justin and Malcolm, they'll have to come back and to stand here. I'm looking at the live chat. There's still 29 people. At least they're logged on. They may be having a cup of tea or checking their own messages, but no one sent us a message. But is there anything we can entice you to ask us about before we wrap up?
That's rather than asking.
Yeah, come on, Colin. Come up. So otherwise people online can't see you. So come on, stand there. So this is Colin McGee. I'm sure most people know him, but if you don't, here he is.
So just going to Malcolm's points on the pleadings and pleadings by prosecutor, historically there's been the start with risk assessment, go to safe work method statement, go then down the lists. I think the courts, and certainly my approach to pleading, is go through the hierarchy of risk controls and look at, well, what is the highest control that you can identify as a prosecutor that would have eliminated or minimised the risk, and plead that as your first particular. Don't go through the whole kind of all the soft measures and then think at the end, oh, actually, if they'd done this, it would have eliminated. And historically, Safe Work have done that in particular. They've, started off with almost exclusively, they should have done a risk assessment. Out of that risk assessment, they should have done a safe work method statement or a JSA and then gone through. Judge Curtis, for anybody who remembers when this jurisdiction first started, he used to say, what's the concrete measure? What's the concrete thing that could have stopped this? Which was really asking that, well, what was the elimination measure? And I think that's something that as a defendant and also as a prosecutor, you should really be looking at is, as a defendant, looking through the particulars and going, well, hang on, risk assessment, safe work method statement, they're all kind of lower order in the hierarchy of risk controls. And obviously, a barrier or a physical thing that could have stopped is the other one. So that's one thing I think to look at in terms of how you plead and how you defend matters. The other thing that Ingmar was talking about in terms of the and also asking of further and better particulars is there is a risk as a defendant's representative when you ask further and better particulars that you tip the prosecutor off to the weaknesses and the holes in their case, and the prosecutor then goes back and amends or fixes up the charge because you've been too clever in your request for further and better particulars. So there is a real balance as a defendant's representative of how much more information do we want to get out of these particulars and how much we're really giving away our defence or the holes in the prosecutor's case. I think they're the 2 points I just wanted to answer.
Although it might be better to tip the prosecution off at that point rather than to leave the prosecutor to work it out on the first day of the hearing and then work out that in fact your defence has disappeared. Anything else for anyone? I should add, Colin, we did actually win Paletti in the Court of Criminal Appeal. We didn't lose it.
We won.
I was leading you.
No. You were against me and you lost.
No, have a look. I was for safe work. I just looked it up. Dean Jordan was against us. I've got a 100% record in the Court of Criminal Appeal. That's why I was surprised that apparently I'd lost one. Apparently not. Any other comments or questions before we wrap up? No? All right, well, thank you. No, on the live message. Thanks, everyone, for joining us. For those who are here, we've got some drinks and snacks, I suspect. Be great if you could stick around for 15 or 20 minutes and say good day before you leave. All right, thanks to everyone online.